everyone. This is Joel Pate from Scoreinc. We're glad to have you with us today on our weekly webinar. Joshua is busy doing disputes today and training new employees and will not be joining us, but I've got Jeff Lohman, who heads our Fair Debt Collection Practices Act department, with us, and we're glad to have Jeff on board. Jeff, say hello to everyone.
Hello. I'm actually excited to be back a part of this again.
Great, great. Well, you know, the best part about launching something, and we're very careful to launch things at SCORE, we don't believe in beta tests. We believe in bringing things to market that actually are proven and work. And when we connected with Jeff well, Jeff, when was it? I guess back in February of this year, up in out in Las Vegas.
I think that's what happened.
We looked at Jeff's operation and then kind of rolled it into ours, and we're very glad that we did. And we've got one of the largest Fair Debt Collection Practices Act departments in the country with a very prominent law firm that supports this service. And of course, that's what makes it work, because it's got to work, or of course it doesn't work. And with everything at SCORE, our goal is not to extract training fees or access fees or things like that from you, the CRO, but instead to provide you with resources that work, and that we make money when you do, and that's just what we believe in here at SCORE. So we're very excited how we have implemented this process, and I'm glad to note that the majority of the cases that are submitted, Jeff, are going through and being accepted by the law firm.
Yeah, that's correct. It's been a great success for the implementation of our SCORE department.
Good. Well, one of the we've got a lot of testimonials, but I wanted to put this one on the webinar here from Jim in Illinois, and Jim was actually the CRO as well as the consumer in this case. He had a legacy. I think it was a $50 account. Maybe it was I'm not sure what it was, but I remember it being $50. And we were able to get him get the account settled, removed from his credit report. He actually paid the $50, so we weren't able to absolve the debt because he'd already paid it. He got $500, and if I remember the stats here, the law firm took the case within like an hour of him submitting the case to us. So it was in the settlement occurred, if I'm not mistaken, 2 or 3 weeks into the process. So he was extremely thrilled with the results, and as has everyone been that has submitted cases to us. It's been a great success. Jeff, I'm going to pop over a audio that we have developed, and we are tweaking it to be able to provide this to our CROs when we get it ready. It can be used either for audio or video or YouTube or Facebook on your website. And we will be able to take this phone number out, and you can superimpose your phone number on this image, and you'll notice within the recording it says call this particular number. We're redoing that to say call the number at the bottom of the screen. So without further ado, let me play this for you. It does have a couple of arrows in it, so it is being edited, but I wanted to give you an idea of what we're working on for you.
Have they called your place of employment? Are they calling your neighbors or even speaking to your underage children? If you answered yes to any of these questions, your rights may have been violated. Did you know that in 2011, the FTC received over 140,000 complaints against debt collectors? 17% increase over 2009. You have rights. The Fair Debt Collection Practices Act, FDCPA, gives you the opportunity to turn the tables on those annoying collection agencies. This could mean money in your pocket. Collection accounts wiped off your credit report. And best of all, it's free. Did I say free? It costs you nothing. Take action now. Fight against your rights. Call 877-876-5921 for your free FDCPA consultation today.
Yeah, so that's going to be really nice when we get that finished. We will be licensing this out so we can provide you with content like this. Let me give you another example of something we're working with one of our CROs to perfect, and it is a landing page that asks questions. Let me show you how simple this is. Actually, let me go back to the beginning here. And it just steps the consumer through the questions. Are you receiving calls from collection agencies? Have they left you voicemails? Yes or no? Excessive phone calls? Calls at work? Third-party disclosures? And then it asks the consumer to complete this questionnaire or this questionnaire here, and then it would email you the consumer's information so you could call them back. So we think this is a great piece of work here, so that maybe you can look through it, make an adjustment like that yourself in your website as well. Well, let's move forward in the presentation, Jeff, and really get into recognizing the violations and submitting clients to SCOR. And it's really as simple as everyone you speak with, asking them this question. I noticed from your credit report that you have a number of collection accounts. Are you receiving calls from collectors or notices in the mail? You can also ask this a little differently as a lead generation process. You could say, hey, by the way, are you receiving calls from collectors? The advertising of this versus credit repair may be a value too. We notice that many mortgage companies are actually receiving applications, or want to make consumers want to make application at mortgage companies, and they actually have live third-party collection calls occurring, and they think they can get a mortgage. So again, another thing to speak with your mortgage person about, and the fact that they may not know that you can help a client with that's actually receiving this third-party collections. And so it's a good way to broaden your base of referral partners as well, something else to talk about. But, this is basically the qualifying question. And then, the next question is that if they tell you, yes, I'm receiving calls from third-party collectors, is you ask these 4 qualifying questions. Have they left you a voicemail? Are they calling often? Have they called you at work? And there's actually one more. Have they called your neighbor, your mother, your father, your brother, anybody but your wife? And let's clarify this, Jeff. A child under 18 years old is okay, right?
Actually, a child over 18 years old would be okay as well. There's some gray area in this as far as the interpretation of the law. But if they're speaking with the children in a manner that would try to disparage the parent, then yeah, that's a violation. But I mean, if they've talked to anyone other than the spouse or a co-signer, then absolutely, that's a definite potential for third-party violation.
Okay, well, let's clear that up because I've been mistaken about this. So anybody but the spouse or a co-signer could be a third-party violation.
That's correct. Yeah, and that's only come up more recently in conversations and meetings between the attorneys in our department. We originally thought that underage children didn't count, but that was clarified that if they're saying negative comments to the children regarding the parents, that definitely that could be a third-party violation.
Okay. And let's talk about this. How would you prove that? What is the proof needed for that sort of violation to stick?
Well, I think there's a slide later on that deals with this directly, but for this point right here, for a third-party violation, it comes down to the credibility of the third party. A lot of times there is no evidence necessary. If the third party is, I want to say believable. It's not like we ever think that they're lying. But if they have the facts straight, where they say, on October 10th at 2 o'clock, I got a call from this 877 number. I spoke with a gentleman who called himself Gary, and Gary told me that my brother owed this amount of debt and that he better call him back, otherwise he's going to get sued. That's enough. Like that's a credible witness, and the attorneys will generally take that case based on that testimony. Because what they're concerned about is they want to make sure that if it does go all the way through to deposition or something like that, and I can't tell you I've ever seen that happen, but I'm saying if it did, that they're going to be able to substantiate the claim and that story of the third party. A lot of times we just ask for a simple email. Have your brother send us an email just saying so-and-so called you at this time. We can use that as evidence, but it's not always necessary. If it's a credible witness, a lot of times we'll just take this off of their word.
Okay, good. I'm glad we clarified that. Let's see, next slide. And, how much can you make? Well, SCOR, if you're a member of SCOR and we're doing outsourced work for you, you can make $150 per case. Non-members can make between $100 and $150, and this is, the breakdown of that. And, you get paid the week after the lawyer takes the case. So, again, we've had some cases, not many, but some cases that the lawyer engages the consumer in the same day, and sometimes I've seen it within an hour, the lawyer is engaging the consumer. And so the next week, actually the week after the next week, so if you close the bill today on Thursday, you would be paid not tomorrow on Friday, not next week on Friday, but by the following week. So it does take the next week, so 2 weeks from the week that the deal closes. So it's a great way to earn extra money, of course, but at the same time, it's a great way to help your consumer because, as I've said 1,000 times, nobody wants credit repair. They just want the loan or the job or the insurance or whatever it is that having better credit will give them. But I can tell you one thing from listening to a bunch of these voicemails, there's a lot of people who there's a pain there. They want to stop these collection calls, Jeff, because they're harassing. Listening to these calls is pretty amazing.
No, you're absolutely right. Absolutely right on that.
Yeah, so, what you're looking for in a client, a good client, is a pain threshold. If the pain isn't high enough, then the consumer won't act, number one, but if the pain's high enough, then you got to catch them at the right time and, and have some way to help them, and, that's what this is all about. So this is the earning potential as well. So, Jeff, let's get into the meat and potatoes of the FDCPA, and with the idea here that we want everybody on the call to be empowered with enough of this knowledge so that they can feel comfortable speaking to not only their affiliate sources, but as well the consumer. So if the consumer begins to ask you some questions, you want to have some information to fall back on. And this recording will be on the website as of tomorrow, but there's already an FDCPA training that is there, which we'll leave there as well. And this PowerPoint presentation is on the website as well. So if you are a member or you're not a member, we'll give you access to our members-only section. And so go to that section, Scoreinc.com, to the members section, click on that link, and fill out the form, and you will be emailed the credentials to be able to view this recording, as well as all of our other recordings, and this very PowerPoint presentation, so you could study this and print these out and feel very comfortable. So let's do some educating today, Jeff, because that's what people want.
Of course. I'd like to start off, Joel, and we haven't done this in the past, but let me touch on that last slide that you had up there, dealing with, or at least your last comments, dealing with the pain that's already there. We've worked with these consumers. Our department's been doing this for over 3 years now, and what we find time and time again with these types of clients is that they feel guilted into receiving these calls. They know they're behind on their bills. They don't feel good about it. They don't talk with anyone about it for the most part. And they especially don't talk about the phone calls they receive and their communication from the debt collectors, because they feel like it's they're required to be put through this. They don't realize the protections afforded to them through FDCPA. A lot of what we're trying to do over here in our department is take out words like harassment, because we really feel like the clients and the consumers at this point, they identify harassment as threats, foul language, rude debt collectors, but it's so much more than that. And that's what's so important about this training, is that you're going to be able to educate your consumers on the nuances of this law and how it applies to almost every single communication that they receive from their debt collectors. And this is information that, hopefully a lot of you have some of this information already, but your clients don't have this information, and it's going to be so imperative that you pass this off to them. And that's also why it's so important to talk with every single client about this, because your clients are experiencing this behavior, and they don't know they have rights. So let's get into this slide here with the USC 1692. That's the United States Code. Congress passed this back in 1977. The purpose was to eliminate abusive debt collection practices. Before that, there were no real laws that afforded consumers any type of protection. The debt collectors could say anything in their attempt to try to collect that debt. The next point here discusses, that the rules apply to third-party debt collectors. So these rules, the FDCPA does not apply to first-party credit issuers. So Bank of America, Chase, Wells Fargo, your car loan company, your mortgage company. Those entities, the banks or the lenders that have provided the original money, for that first transaction, they do not apply. So this only deals with third-party debt collectors. The reason that this service is free to your consumers is because there's a fee ship provision written into this law. So Congress, in all their wisdom, understood that consumers experiencing financial hardship, the type of consumers who are getting these phone calls, can't afford to pay an attorney $2,000 to $3,000 to represent them on this case. So in addition to your client being able to receive up to $1,000 in damages, the debt collector has to pay the attorney's fees for this. So the attorneys aren't doing this for free. It's not pro bono. They're not doing this out of the goodness of their heart. Everyone makes money. But they don't have to charge the client because they can charge the debt collectors to pay that. This last note here, I think, is very encouraging for our department. In 2011, the FTC received over 140,000 complaints against debt collectors. As you can see there, it says it's gone up 17% since 2009. So it's continuing to grow. It's a constant problem. These debt collectors aren't going anywhere. We open cases against them all the time, and it doesn't really even seem to faze them. I've been in conversations before with some of these debt collectors, and they just consider this a nuisance and a cost of doing business. So they're making plenty of money doing what they do. They don't seem to be in any hurry to change their practices. And your consumers need to know their rights. And that would be it for that slide there. So let's talk about voicemails, because voicemails are by far our number one violation that we find. And voicemails deal with this FODI violation. So the first thing I want to talk about is the compliant message. Every single time a debt collector calls you or calls your client, they need to tell them the name of their company and that it's in reference to the collection of debt. You can see here the ACA approved message, and I'll kind of read through it here briefly, but these are the messages that last a minute and a half on your client's voicemails, and it usually starts with, "This is a message for Mary Smith. If you are not Mary Smith, please hang up now or disconnect. If you are Mary Smith, please continue to listen to this message. There will now be a 3-second pause in this message. By continuing to listen to this message, you acknowledge that you are Mary Smith. Ms. Smith, you should not listen to this message so that other people can hear it, as it contains personal and private information. There will now be a 3-second pause, yada, yada, yada. This is Bob Jones from ABC Collection Company. This is an attempt to collect a debt, and any information obtained will be used for that purpose. Please contact me about a very important business matter at," and they leave their phone number. That addresses a few different things, and I'll kind of just touch on it here, breaking this down. One is they're not allowed to disclose information or that personal information to third parties. That's why it says, if you are not so-and-so, hang up now. If they did not say that, and it was, Mary Smith's sister listening to the voicemails, that could be deemed third-party disclosure. If their kids around, something like that. Again, that's that third-party disclosure part. The reason that they disclose the name of their company is, by law, they have to. They have to disclose that it's the collection of a debt. It's not enough to say this is regarding a personal business matter. They have to say somewhere in there that it pertains to the collection of a debt. And I think, Joel, do you want to go to the next slide real quick? I don't know. I think this is where we, let me play some of these voicemails that aren't compliant. So again, I want to touch on the fact that every single time a debt collector leaves a message for your client, or for a consumer for that matter, a voicemail, they have to state that they are collecting a debt and the name of their company. So what I'm going to play for you here are some real-life voice messages that our clients have received. We have opened cases based on these voicemails, and I'm going to just kind of go through them and play them for you all, and then we'll kind of talk about what's missing and why they are violating. So the first one here, I believe, has no disclosure that it's the that they're collecting a debt.
Babu Singular, This is Sam Jones. It's essential that you return my call. This is the office of Alan C. Smith, 888-275-6399.
Received July 10th at...
Okay, so you can see there that they said the name of their company, but they did not say anywhere in there that they're collecting a debt. And when you think of this from the debt collector's perspective, you know, saying that you're a law firm and not saying that it's collecting a debt makes this client now think, oh my goodness, what, you know, am I getting sued? What's going on? I better call them back. It's important. Well, they're really just trying to collect on a, you know, a credit card that they didn't pay 6 months ago. So that's, you know, that's the violation in that one, with that one there. These next three, I'm just going to play straight through, and none of them have either the disclosure of the company name or that they're collecting a debt.
Hi, this is a message for James Mayer. My name is Jan Malmoos. Call my office, 1-800-828-1110. My direct extension is 1379. Thank you.
Such messages for Robert Perez. This is Kristen DiCarlo. Please give me a call back at 1-877-865-9750. Thank you.
You have 7 saved messages. Saved message.
Dan, my name is Dan Elmore. I need a call back at 866-654-8514, extension 6418. Thank you.
2 weeks.
So these are the messages that your clients and consumers are receiving every day. And that's why I started out with saying that, you know, we don't really use the word harassment too much over here anymore, because when your client hears that message, they're not really thinking, oh man, I'm getting harassed. You know, who can I call to protect my rights? They don't know that that violates the law, but it does. It's called a FODI violation. It's actually a case. It's FODI versus NCO. And in this case, the court determined that a voicemail does constitute communication. So that is where this requirement comes from, that every time they leave a client a voicemail, they need to state the name of their company and that they're collecting a debt. Our clients received money based on those voicemails. So that's, you know, it's important that everyone knows that.
Yeah, and that's an excellent point, because, you know, if you go on YouTube and you watch, there's one particular YouTube video with ABC News. And, you know, you're talking about harassing phone calls. I mean, they are harassing, okay? So very good point. These are not harassing, but they still are in violation. And every one of these voicemails, every one resulted in a case being taken by the law firm, money awarded to the consumer. And, you know, that is maybe the takeaway for today, Jeff, is that that's against the law. It doesn't have to be, quote, unquote, harassing, cussing, threatening, et cetera, et cetera.
That's correct. That's correct. And that's where we're getting, you know, trying to get our message to be for these consumers. You know, when you submit a consumer to us, and we'll get to that as far as the submission and submitting their information, a lot of these are not cases up front. But what we do is we educate the clients. We explain to them what is, you know, a violation and what's not. If it's not a violation, we explain to them why. That testimonial from Jim, that, you know, he had voicemails. It was a violation right then and there when we spoke with them, and we were able to open it that day. But, you know, the reason we have a department around this is because it takes follow-up, it takes education, and that's what we're doing with these consumers. And that's hopefully what you're going to be able to do when you have that initial conversation with the consumers about, hey, are you just receiving phone calls from debt collection companies? Did you know this? So the second violation we deal with mostly, or I guess the second highest amount of violations we receive are from excessive phone calls. So the first thing I want to talk about is the court's kind of definition of communication. The court does not define phone calls, the actual act of making a phone call to a consumer, as communication if they're not talking with the consumers. So there's a couple things that are important to dealing with excessive phone calls. First and foremost, the clients need to keep some sort of a call log. If they're not, we can send them one. I mean, really, they could just take a blank sheet of paper and write down the number that called them and the date and the time that it called. That's enough for us to have proof. And perfect, Joel, thank you. Here's examples of some call logs that we've used to open cases. And you can see here, we don't need to know who the company is, because that's what our department does. the last thing we would ever do is ask your consumer, hey, that 866 number that says call free, do you know who that is? Because we need to figure that out. No. We do the calling ourselves. We figure out who it is. We break down these call logs, and we figure out how often they're calling and if it's a violation. What we find a lot with these call logs is that, companies like NCO use multiple phone numbers trying to trick the consumers into picking up the phone. So, you might have 2 phone calls from an 866 number, 2 more phone calls from a 213, and 3 more from a 714 on a day, and the consumer, not knowing who it is that's calling, doesn't necessarily know that that's NCO, and I'm not saying those are their phone numbers. I'm just saying that they don't know that it's that same debt collector calling them 6, 7 times a day. They think it's 3 separate companies. So that's why we need to track this stuff, and that's why we ask the consumers to track this. You do not have to wait until a consumer has a call log to submit them. If they're getting phone calls from a debt collector and they don't even know who it is, submit them. That's what we'll do with them. We will show them how to do a call log. We'll send them call logs. We will educate them on what to look out for and have them send it back to us. We're doing the follow-up for you to create those cases. Defining excessive phone calls is a little tough, because there's no exact number. I'm a math guy. I love, exact formulas and numbers. It's like, tell me 2 a day, and that's perfect. It's not that easy. We have taken a case before and actually gone to court on a case where the consumer received 6 phone calls in 1 day from one company. We felt that was strong enough as harassment. We don't have the results of that one yet, though, to find out what the determination was. But what happened was the consumer spoke with the company that morning, said, here's the deal. Please don't call me anymore. They called them 6 more times that day. That, we felt was clearly harassment. But that's not the only definition of it. If they're receiving 3 phone calls a day for 2 weeks straight, we feel like that's harassment. If they receive, a lot of times what you find is 4 phone calls one day, 1 phone call the next, 2 the next after that, 5 the next after that, and again, that's why it's so important to have this information in these call logs so that we can keep track of this. And that's the proof required. It's these call logs that are required to create a case for excessive phone calls. And they're not as easy as a voicemail violation, but we're working with these every day. We're going through them every day. We're dealing with consumers experiencing harassing phone calls every day. Let our department take care of this for your clients. If they're getting phone calls.
Okay, and so on that point, let's address that, because I think that this is a area that we've not clarified clearly enough. If you ask your consumer, are you receiving calls from third-party collectors, and they answer the question yes, then ask them the next 4 questions. Do you have a voicemail? Voicemails are golden, okay? Are you receiving excessive phone calls, and have you begun to make a call log, okay? If they haven't, instruct them how to do it, and you should create one of these yourself and provide it to your consumer, and very easily done. And then if they say, I'm getting repeating phone calls, then go ahead and go to our website, and we'll show you that in a few minutes, and fill out the questionnaire and let our department begin to communicate with the consumer, because we can ripen the case more easily than you can. Okay, so we do want you to go through a level of screening, but don't screen out the people that you don't know if it's a violation until you reach that level of education in which you absolutely can understand this. So we encourage you to complete the questionnaire so that we can take this over, and we can help the consumer in many cases better than you can, or that you're prepared to at this time. Would that be a correct statement, Jeff?
That's correct. The only caveat I would add on to that is the fact that these clients that are getting excessive phone calls eventually will get voicemails. So even if they don't keep call logs, it's still worth a follow-up call in a couple of weeks. And the education on what to look out for voicemails. You're not only going to find one type of violation when dealing with collection activity. Finding a client that's getting excessive phone calls is great, because you know that they're going to experience some type of violation in the near future. So just understand that too, that when you educate them about keeping a call log, make sure you also say, hey, if you get any voicemails, I want to know. Don't delete them. We want to know as soon as you receive a voicemail. So that's important to keep in mind as well. So the third violation we deal with, and really, so there's a lot of types of violations of the FDCPA. There's a lot of parts to it. What we're explaining to you is a practical application of FDCPA. These are what consumers are dealing with on a day-to-day basis. And this third one here deals with calls at work. This is a very simple one to prove. It's a lot like the third-party violations we were discussing earlier. A debt collector is not allowed to call the consumer's workplace after they have been notified that that consumer cannot receive calls at work. So consumers that are receiving calls at work, the first step is for them to tell the debt collector that they cannot receive calls at work. After that, if they receive any more phone calls, that's a violation. They don't need to fax them or mail them a cease and desist letter saying, don't call me at work. Verbal communication, that verbal notification is enough. The way we prove this violation is that we need the information from the consumer. A lot of times that information comes in the form of a call log where they say, on October 4th at 2 o'clock, John Smith called me from this number. I said, I cannot receive calls at work. Do not call me again. And on October 10th at 3 o'clock, I received a phone call from this number. It was John's associate, so-and-so. They called me again. That's enough. We will open that case. That's basically it. I mean, again, it's so simple. They just need to inform the client, keep some record of it, and then if they call again, you know, that's a violation.
And there's, you know, do you have to get the phone records of the company?
No.
Is it just your word against theirs, or what is the process here?
See, here's the thing.
Let's clear this up.
Well, okay, here's the deal with that, is the debt collectors by law, they have to keep all these phone records. So when we say, you called our client at 2 o'clock on October 4th from this phone number, they see that on the other end. The debt collector has that information as well. And keep in mind, we're not calling John Smith and saying, you harassed our client, you know, pay up here. We're contacting John Smith's company's legal counsel saying, you know, hey, here's what happened. Here's where the call came in. That legal counsel then goes to John Smith's company and says, we need your phone records. Show this to us. Oh, yeah, you're right. You did. And, oh, yeah, you called again. They settle. That's why it's that simple. Because, you know, we're not doing this, you know, the world of FDCPA litigation is not this, you know, is not void of communication. It's not us saying we'll see you in court. You know, they don't want to go through the extra expense of going through court. So they're trying to settle this out just as much as we want to settle out for our clients as well. You know, we're not submitting anything. We're not you know, trying to what's the word? You know, fluff the other side into thinking that you know, we're going to strong arm them into paying us. It's, you know, they understand the process. We understand the process. Quite honestly, we have a relationship with most of these other counsels so that they get, you know, that's how we're able to work out these settlements and get, you know, clients like Jim $500 within a couple weeks. It's because they know that what we're doing is legitimate, and they know that we're building strong cases, and they're just as encouraged to settle as we, you know, as we want to settle quickly.
Yeah, so excellent point, because I've heard, you know, questions about this. I actually read on a particular website trying to sell a recording device that, you know, basically there's no way to prove these calls at work, but you make an excellent point. You know, we're going to allege on behalf of the consumer that the consumer was called on these dates. So it is important, is imperative that the consumer be educated to say, on this date, this person called me and I told him I couldn't take calls, and then on this date they call back. Okay, because, just to reiterate this, when the complaint is filed, you know, the collection agency is going to go to their records and they're going to see it, they're going to hear it, and they're going to know that they ran the stop sign and a picture was taken. I mean, it's just that simple. If you can imagine running a red light and they take your picture, they got, you know, your face, they got your license plate. I mean, you know, you're done. You're paying the ticket. And so that's effectively what this is. So I'm really glad that we spend time here, because it clears up, I think, a misunderstanding or a lack of understanding about, you know, the fact that the consumer themselves only have to prove the time and the date. And it would be helpful if they know who it was that called. That would be helpful as well, I would imagine.
If they just say it was a male that called me. I don't remember that. Again, information like that's enough. As long as we're able to go to the defensive counsel and say, look, here's the information we have. Check it with your records. They're going to be able to substantiate our claim.
All right, now, good question that's come in, and I've had this before as well. What if they call it on their cell phone while at work?
So what if they call the consumer's cell phone while the consumer's at work? Is that the question?
Yes.
Okay, that does not count because it's not a work phone. The consumer does not have a legal right to have to keep their, a legal obligation to have to keep their cell phone on while they're working. The consumer could very easily just turn off their cell phone and not have to be bothered while they're at work hours. So
okay.
that necessarily is not a violation.
Okay. Now, this would be a call at work, but really a third-party violation when a collector calls the payroll department or the human resource department or your boss or something like that. That would be a third-party disclosure, not a call at work.
That's correct. In fact, we're working on a case right now regarding third-party calls at work because they were calling other people. We're going to get into third-party disclosure in the very next slide here, but addressing that one, when a debt collector calls a third party, it's only for locator information. That's it. They can't disclose anything about the debt. So, if they're calling the secretary and telling the secretary that this is, Acme Debt Collection Company calling for, Mary Smith, it's important she calls us back today, just saying that they're Acme Debt Collection is enough to violate that third-party disclosure. They can only say, oh, this is a personal business matter. Please have her call us back. That's it. The funny thing is, regarding like FODI violations and all those voicemail violations for consumers, it's the exact opposite for third parties. In third-party disclosures, they can't say anything about the debt. They can only say it's regarding a personal matter.
Okay, very good point. And that's regardless of who they call, family member, friend, neighbor. I mean, give us some examples of third parties that you experienced debt collectors calling as a way to find the primary debt holder or obligator.
Well, I'll tell you, let me start with our biggest challenge with third-party disclosure, is that a lot of times these third parties just don't want to be involved. So that's usually our biggest challenge is that, they might have called Mary Smith's neighbor, and Mary Smith's neighbor might have relayed the information, and Mary Smith is now very embarrassed that her neighbor got called, but she doesn't necessarily want to go back to her neighbor to get details about it and, tell the neighbor that she wants to sue them. That's usually our biggest struggle, is getting both the consumer and that third party to get us the information we need to be able to open that case. Again, the neighbor's never going to have to go to court or anything, but a lot of times the client themselves just doesn't want to put the third party through that. But no, I mean, we get calls to ex-wives, ex-husbands, mother-in-law, in fact, I think someone the other day had calls to an ex-girlfriend, neighbors. These calls are happening all the time. I think if you Google, anyone's name, it can come up with relatives and stuff like that, so that, if someone's not returning the debt collector's calls, if that consumer's not, they're going to start, branching out and calling other people if they're, not a very, I don't want to say legitimate, but just not a very up and up type of company. That type of behavior you rarely see with the large debt collection companies. It's usually the smaller ones, and some rogue agents that then, think that they're going to get smart and start calling other people. But, it's all over the place. I mean, I had one person who I think every neighbor on their street, like every person down their street, was called, trying to, quote unquote, locate this person.
And, the very fact that they called isn't a violation. It's what they say during the call.
That's correct. So in dealing with that, so when they call the third party, they can only ask for locator information, and that would be like phone number and do you have their address? Do you know the number we could reach them at type of stuff. And they're not allowed to call again. That's important, unless they believe that that person was not telling the truth. So if they call the consumer's mom, and the mom says, I haven't heard from them in 3 years, I have no clue where it's at, where in reality, she sees them daily, that's not, and they call again the next day to say, hey, just following up, want to know if you know where they're at. That's not necessarily a violation, because again, the third party wasn't really truthful about it.
Well, and that's very, I mean, that seems esoteric and very difficult to prove and legitimize. I would imagine that if I was a debt collector, I would think that everybody was lying. So,
well, I probably would too.
Yeah. So, is that difficult to make that stick?
Well, here's the thing.
The debt collector, well, I thought they were lying, so I called them back. I mean, that seems pretty difficult.
Look, at that point, if the clients, let's say it's the mom. If the mom's getting a call a day or talking with them every day for 5 days, now we're talking about, actually the mom might even have a case at that point. At that point, that's going overboard. But if they called again, I just didn't want to create this, line where if they called again, oh, that's an immediate violation, because it not necessarily is. But if they're calling in a consistent manner, then yeah, that's a violation we'd want to look into, either harassment for the third party, which we've done that before. We've opened cases for the third parties because they were called so much, and or third-party disclosure case for the consumer themselves.
Okay, so while we're on this point, what would be the violation to the third party?
Excessive phone calls. If they continue to call after being told that that person doesn't live there, that's an excessive phone call case.
Okay, under FDCPA.
That's correct.
Okay, very interesting. Okay, so there's really an extra element there that you guys could consider, because I didn't realize that. So very good. I'm glad that we dug deep enough to ferret that out. So good. Well, anything else on third-party disclosures, Jeff, you want to cover?
No. Again, we kind of touched on half of this at the first part. So let me reiterate that if it's I don't want to use the word viable, but if it's a consumer, if it's a third party that knows what they're talking about, that has dates and times and phone numbers, that's really all the proof that we require. They don't have to have kept a call log. They don't necessarily have to write a letter detailing what happened. If they're believable and they have their facts straight, that's something that we can take. There's not a lot of proof required with the third-party disclosure. So just keep that in mind, that if that did happen, if the third party did get let me back up on that. If the debt collector did disclose personal information to the third party, we'd like to talk with them. There's a good chance that that's the case. You don't have to do much more work than just getting them over to us.
Very interesting. Let's see. I had a question there. Let me. Okay, so the third party, if they're called X number of times, let's say 5 times in a week, would that be something, or 3 times in a week, or 3 times in a couple of days? Would that be enough to potentially bring a case for excessive phone calls? Or is there a number, or would that, what kind of basis would you like for people to take away from this call?
Well, I think that question is asking, how many phone calls does it take to be potential violation to the third party for excessive phone calls? Did I understand that correctly?
Yes, that is correct.
Okay.
That is the question.
Okay. So I want to say that the standard for that is a lot like the calls at work. If the debt collector is calling the mother-in-law and the son-in-law or daughter-in-law does not live there, and she explains that to this debt collector, but the debt collector proceeds to call 4 more times over the next 3 days, that is a great chance of being a case. I mean, obviously it depends on some more facts, but that is a great case to have excessive phone calls, because why would they continue to call there other than to have the intent to annoy and harass?
And again, the proof that we're looking for is really found at the debt collection company that's calling, because the third party needs to be viable enough and believable enough, but to say, look, I got called on Monday, Tuesday, Wednesday, Thursday, Friday about 2 or 3, 4 o'clock in the afternoon. And so when we interview that person, that third party, we gather that information, find out who, get the phone number, find out who it was, and you guys call them back and say, and what would you say to the third-party debt collector? Hey, you've been calling our client, and by then you would know the name of the company, and you would formalize the complaint, and when the complaint is submitted to the company, it arrives over at their in their compliance department, I guess, or their legal department. Having those dates and that phone number that was called, that company's just going to look up that number and say, well, golly, looks like we called that number 5 times in 3 days, guys. That's a problem.
That's correct. No, I mean, we don't necessarily call them up first. We usually, issue a demand letter and a complaint and stuff like that. But no,
Right.
that series is pretty much exactly how it works. Their counsel will look up this information before they get back to us.
Right. Yeah, so again, the burden is on the third party to provide minimal credible information that the lawyers believe is credible, and they can, have something to sink their teeth into, so to speak, to be able to move forward the case and feel good enough to take the case and invest the dollars. So that's really what we're after here as kind of what are we after in order for the lawyer to take the case? Well, enough credible information for the lawyer to want to invest their time and money.
That's correct.
So that's what the evidence has to eventually, before we submit it to the law firm, whether the consumer or the third party has that initially, that's what we're going to have before we submit the case.
That's correct. And that's what you'll see. I mean, we're going to get over here to reporting and statuses, and that's what we do. I mean, we don't submit to the attorney anything that is not a case ready to be, processed and filed. I mean, that's the secret to our success here is, we've got great relationships because we provide a great product to these attorneys. You had touched on something earlier, Joel, when you made that comment about running a stop sign and getting the picture taken. I want to comment on that because this law is statutory. And, I mean, it goes without saying, a law is statutory. But what I mean by that is the fact that these consumers don't have to prove that they were emotionally distressed, that they developed a heart problem, and, they lost sleep over it. That's not what this law and these damages are about. If you prove the damages, your client's entitled to some money. And that money might be anywhere from $200 to $2,000, depending on the state and the type of violation and all that stuff. But they're entitled to money because the debt collector broke the law, not because of any distress or anything like that. So a lot of these consumers, I'm not going to say a lot, but some consumers feel like, well, again, it's that guilt. They should experience this stuff. And that's the part we try to get past with them of be aware of these behaviors. They break the law. You're entitled to some money.
Very good point. And one that really needs to be driven home because unlike the the FCRA, okay, unlike the FCRA, you've got to prove actual damages. In this case, you don't. If we take your picture, running the stop sign, we got you, okay? And that's the difference between the statutory clause of the FDCPA. But while we're there on that point, I want to encourage everyone to begin to look for cases that the debt has been re-aged. We had a meeting with Jeff and his lawyer a couple of weeks ago, and I've actually failed to put out a notice to everyone, but I've been speaking to people one-on-one about it, and I want to take this opportunity. Jeff, exactly what are we looking for there to attempt to determine if there are violations occurring with regard to re-aging the debt?
So what we're looking for, and I might have this subsection incorrect, but if I remember correctly, it's subsection E of FDCPA, talks about reporting misinformation to the credit reporting agencies. And we know that this overlaps with FCRA. The problem is, in the model that we have, FCRA, you've got to prove damages, and there's more to it. It's a lot harder thing to try to, win and try to prove those damages. So we're looking at this subsection of FDCPA, and there's not a lot of case law out there. In fact, what we found so far is that there's only one case out there that even mentions it, and it deals with reporting that wrong information. So talking with the other departments within Scores, it seems like that we could find these violations in the re-aging of debt. So that's, and Joel, you kind of already touched on this. We're looking into this right now, but we're looking to see, if a debt collector reports on the credit report, and you're able to see how it re-aged the debt. And what I mean by that is maybe it first reported, October of 2010. The client's never made a payment, but then miraculously they show that the last payment made on that was, December 2011. That's the type of stuff we're looking for because we know that that is erroneous, and we feel like that would be a violation of the subsection and that we'd have cases. So we're trying to build some strong cases right now on events just like this, on facts like that, where, it's a third-party debt collector We know that the client has not made payments on this type of stuff, but for some reason the third-party debt collector added new information or changed the information in a way that would be more beneficial to the debt collector itself.
Right. And so let me make that a little more clear. We know for a fact that when the consumer goes from one third-party collector or from the original creditor to a collector, we know that the third-party collector is re-aging the debt at that time. So we know that evidence is there. So that's one level of evidence that we're looking for. But the next level of evidence that we're really looking for is if NCO, as an example, buys a debt, reports it as, let's call it June 2012, and then miraculously the same debt, without any payments being made whatsoever, is now being reported as October. And that is specifically what we're looking for. Would that be very clear about that, Jeff?
Yes, that's a better explanation of it.
Okay. And unfortunately, a lot of the credit monitoring, most of the credit monitoring, everyone that we've seen does not have enough data to help us support this, okay, because they usually don't report the date of last activity, or, and they don't update it. So you want to look at that. We definitely would need to be looking at tri-merges here, and it's a little more difficult to get the data off the credit monitoring, and most of SCOR's clients run their business off of credit monitoring. So it isn't, that's a part of the problem in trying to prove this. But but we do want to put this out there for you. So if you see that happening, please present it to us. There's one more question here about excessive phone calls, and I think it's a very, very valid question, and it's regarding cell phone minutes and the fact that collectors just keep calling the same number and burning up the consumer's cell phone minutes. Is that a part of this excessive calls, or would just be the fact that they called excessively, be the real violation?
The excessiveness of the calls would be a violation. Dealing with cell phone burning up minutes and text messages, that is found under the TCPA, the Telecommunications Protection Act, and that's a completely separate type of law. This, FDCPA deals with the number or the excessive amount of phone calls.
Which effectively is the same thing, but, very different here.
Yeah,
so,
different intent.
Because if you're calling excessively, you're burning up the minutes, but it's two different reasons for, or you can't go into the FDCPA and say, hey, you're burning up my minutes. You have to say you're making excessive phone calls. So, okay, well, let's move forward. The next slide here is the questionnaire, and it's a pretty bad slide of the actual website, but it's gives you an idea of what information that we're looking for. And so if you are a member, actually, let me just go ahead and go over to the website real quick and just show you around on the website, because we've really made it a great resource for you. Well, sorry about that. Let's see. There we go. And so you would navigate to the FDCPA tab here on the right. And if you want more information about this, this is the form to complete. And as you go through this page, we have the recording that we've already had on this topic is located right here. The slideshow that we're actually the slideshow that we're looking at right now is hosted here as well. So you could pull this up for to train your staff with or to review later. So it's the same presentation. It'll come up on your PowerPoint. Okay, that'll be very helpful. These are the recordings of the voicemails that you heard earlier, so you can re-review those. If you want to become an affiliate with us at this time, you complete the affiliate application here, print it out. We will be moving that to EchoSign in the next few days. We also have to have a W-9. These are a few of the testimonials. This is some advertising information. And if you are, if you want to communicate with this particular department, call the number here at the bottom, or it's at the top as well. And the email address, and we need to make it more prominent here, is FDCPA@Scoreinc.com. Okay, so we had that's the direct line to the FDCPA department. And this is some background information on know your rights, voicemails, excessive phone calls, third-party contact, as well as the questionnaire. So if you've got a case, we want you to come to this form and complete it. And Jeff, let's talk about the response times and what they could expect.
Well, if it's submitted between 9 to 5 Pacific Standard Time, we'll get to it within about 30 minutes, I think, is our tops right now. And we'll reach out to the clients. If we're not able to get a hold of the client within 24 hours, we'll notify the representative that submitted it, and that's the importance of like the service rep email there on the top left-hand side and the service rep phone number. A lot of times what we find is consumers who are getting phone calls and harassment, if they don't recognize our phone number, they're not going to pick up no matter how many voicemails we leave them, so that's why we'll get back to the representative to help us get in contact with them. I think somewhere there at one of the points on those screens it will say, please let the consumer know that they're going to get a phone call from a 714 area code, and that helps us out. Now,
and actually it's right here on the questionnaire. And
okay,
the email that comes to the consumer after, because we're getting the consumer's email address as well. So the email that comes to the consumer indicates to the consumer that the call will be coming from area code 714.
Perfect.
So very good
at that point, something that's like a voicemail violation, if we identify it as a violation at that time and we speak with the consumer and everything checks out, they will be speaking with an attorney within about 20 minutes. Again, we understand. We have built this model around the fact that it is hard to get consumers on the phone. So we prep the consumers to look out for a 323 area code. And at that point, the attorneys will be calling them. The attorneys spend about 5 minutes on the phone with them to make sure that all of our information is correct. We do the job in our department to prepare the consumer to speak with the attorney. So, we want to make sure, first of all, that it's not business debt. That's usually one of our biggest hiccups is if we didn't catch that and it gets to the attorney, that won't get approved because it's business debt. We make sure the client is prepared to have that conversation. The conversation with the attorney lasts about 5 minutes. At that point, the attorney will let us know that it's a signed case, or if it is rejected, for what reason it's rejected. And that's it. I mean, we notify a score, with the reports of what's been signed and where the statuses are at. If the consumer does not have an identifiable case at that time, we will denote it here in our reports. And Joel, if you'll go back one slide, I think it talks about the statuses. I think. There we go, perfect. So these statuses are informational for the CROs. This is what we use on our end to, follow up with these leads appropriately. Contact attempted means that we were not able to get a hold of the client, and again, we get back to the service rep to help us get in contact with the client. Working lead means that we're getting the information required to submit it to the attorney. For us, really, to tell you what that means, it means that it's a client who isn't necessarily experiencing the type of collection activity where we feel like it's going to be a case soon. That's different than insufficient evidence, because insufficient evidence is someone who is experiencing collection activity from a collection company that we know is going to violate soon. Maybe it's GC Services or Genpack or NCO. We know these companies, we know their behaviors, and we know to follow up with that client, every few days to make sure that they're saving their voicemails, that they're keeping a call log, because we know that client's, generally going to turn into something good for us. Whereas, differentiate that from working lead, where we want to follow up with that client so that if they do start getting harassing activity, they remember us and they know to call us, but it's not someone that we necessarily feel is going to have a case soon. So that's the difference between those two. Once we identify a case and we have the evidence, we send the consumer the contract. I think that's in the next slide, but you don't have to go there yet. But it's basically the consent to represent. It's the client agreeing to have the attorney represent them. Once the contract is emailed back to us, we submit it to the attorney, and then at that point you can see that it's sent to attorney. Once it's with our attorneys, these are the 4 statuses. There's rejected, which obviously means it's not a case. Usually what that means is it's not a viable defendant, or we didn't catch that it was business debt. Those are usually anymore the only two things we deal with. Let me touch on
Let me interrupt you there, Jeff. Let's add to that government debt as well. Business or government debt?
Correct. Just usually government debt doesn't make it out of our department. We catch that pretty quickly. It's for some reason, it's because, it's a chase card, that the consumer had a business 5 years ago, and we, in our conversation with them, we didn't catch that. That's usually the type of stuff that if it does get past us, that would be the type of information that would make it past our department. IRS
yeah, but let's
debt,
go back. Let's go back because we did not cover this. Let's go back and cover what kind of debt does not qualify. So business debt and any type of government debt, including parking tickets, student loans, anything like that.
Parking tickets, yes. Student loans, if it's with a servicer. If a student loan ever goes to a collection company, doesn't happen often, but if it does, that does qualify. Can't do anything about IRS debt, but I've never heard of the IRS really harassing people anyway. I have been seeing some case law from a while ago where it dealt with like a water bill, even a city water bill that went to a collection agency. That could count. Now, that's different than a parking ticket because a parking ticket, you're not paying for services, whereas a water company, you are. But for the most part, business debt, that's what we're going to deal with on a daily basis is business debt, student loans if it's still with the student loan company. There is absolutely no protections for student loans if it's still with that company. There is nothing. There's no statute of limitations on that. There is nothing you can do if it's with either a servicer or the lender that issued the student loan debt. So we have
that, right?
So there's rejected processing, which just means the attorney's waiting for some more information. Sometimes they want a letter from the consumer. Just sometimes they want that letter from NCO to verify that it was NCO that left the message, type of thing. Obviously, a signed case means you get paid. Pre-lit is a little bit different. So pre-lit usually means that maybe the consumer used to have a business and they don't know what this underlying debt is that third-party debt collector was collecting on. So to be safe, what happens is the attorneys know on these pre-lit statuses not to file them, but instead they're going to still negotiate with that third-party debt collector. So on those pre-lit statuses, the attorneys get to work on the file. If they get a settlement out of it, great. We get paid at that time once they get the settlement. However, they're not going to get to the point to take it to court because they're not sure enough on the facts that they would win. And at that point, really, the attorneys have to worry about sanctions and stuff like that if they pursue cases that they didn't have all the correct information on. But that's, pre-lit's very small with what we do. It's right now I think something like less than 7% of our overall business. And again, once it settles, then everyone gets paid out on that one anyway. We just give the attorney some room to try to negotiate that instead of just rejecting it, because that's what they used to do in the past.
Good point. Now, the way our system works is on every Monday you receive a report from our office here on all your cases that you've submitted. So you'll receive a list like this. Okay, so and notice of how much you've earned for that week as well. So that's the way we will operate. This is the contact information for the FDCPA department. Again, remembering to always tell the consumer to expect calls initially from the 714 area code, but this is the email address to contact the FDCPA department, and as well as the phone number. Remember, now I've got 9 to 5 the Central Standard Time. I should change that to 9 to 5 Pacific Time, which is a big difference, obviously. That you guys are operating there in California?
Yes.
Okay, well, good. Well, Jeff, I think we've had another great webinar, had some good questions, and we're over our 1 hour that we usually try to hold ourselves to, but we've had a great call. Any parting comments that you would like to give us, Jeff?
No, we're doing great. We love working with all the CROs out there. We love helping out clients. So, we're here. Questions you guys have, any follow-up questions, you can either email to Joel or to the FDCPA email there. All of our representatives there. That email goes to a few different representatives, so we're always able to get back to you pretty quickly and address your questions or concerns about clients and stuff like that. So, no, it's been great, and looking forward to more business.
Good. If we've not addressed your question on today's call, please just email us at the FDCPA@Scoreinc.com, and we'll get back to you with, very quickly with a response to your question. If we need to, we'll give you a call, of course. So, Jeff, it's been another great call. We wish everybody a great end of the week, a great weekend. Be safe, and let's all be profitable next week. Now, let me remind you that next week we've got Troy Hitt back on to discuss building your business. I don't think anything else can be said about the value of Troy's wisdom and information, other than the fact that they're smart enough that they actually turn down 200 customers a month, Jeff, because the consumer does not yet meet their criteria and their non-negotiables. So if you're turning down 200 clients a month, just imagine the value of your business and the power of your business. And you don't want to miss a presentation by such a powerful person. And we've got the recordings from the last 2 or 3 sessions on the website as well. So be sure to ask us if you want to go and go to the Scoreinc.com website, the members section, and you do not have your credentials to log into that section. Fill out that form, and we'll forward those to you right away, so you can be able to access that part of the website over the weekend and train yourself, because that's the key. You've got to do the training. I've been reading some additional books of late, and every time, Jeff, I get a book out and I realize how much more I have to learn and how easy it is to learn these days. You can listen to these recordings while you're working out or cutting the grass or walking or whatever you're doing. And so it's just, this is a time of year to be educating yourself so that you can, be prepared to do more business.